Today I want to talk about the times when in the United States you can get sued for the shit that comes out of your mouth. And I've talked in the past about the times you can go to jail in the United States for the shit that comes out of your mouth. But now I want to talk about the times you can get sued for it. And the main way that is something called defamation. Defamation is the combination of two torts. It's like one word that covers two torts. By the way, this is the first time I've ever taught a torts class in VR. Tort, French word, means wrong. Wrong in the sense of opposite of right. Like I have rights. If you have rights, then a wrong is something that breaks your right. But we don't say you did a wrong that broke my right. We say you did a tort that broke my right, because back in 1066, some French guys took over England. So typically, if I was going to start with an ordinary torts class, I would go with the original common law stuff. But because you've got this case coming around, and I think that the speech torts are going to be the ones that might maybe get implicated here, then I thought I'd begin with that. So defamation is a combination of two speech torts. The two speech torts are slander and libel. They are exactly the same thing, except that slander is something that you say, and libel is something that you write. Well, as we stand here in VR chat, and as Juicy is recording me, you know that there's plenty of ways to communicate other than speaking and writing. So am I saying that if you don't speak it or write it, that it isn't defamation? No, it still is. What we do in that case is we look at the means of communication and we say, is it more like speech or is it more like writing? And the major thing that defines the difference is permanence. So, don't take this as firm legal advice, but my general feeling is probably what you say in VR chat when you're not being recorded is probably more like speech, so it's probably slander if it is defamatory. And what you would, maybe if you were recorded, if you're recorded on purpose, that would be more like libel. Why does it matter? It matters very little. The only real difference is that in cases of slander, damages must be proven by the plaintiff. In other words, the plaintiff has to prove I actually suffered as a result of this. Unless one of four things is true, and I'll get to those four things in a minute. But what libel and slander have in common is, first and foremost, it involves a statement made to a third person, okay? So when you talk shit to some other person, to their face, and there is nobody else around, that is not defamation. Defamation is what it is when you talk shit to somebody else about somebody else. Okay, about a third person. All right, now, what constitutes the talking of the shit? The first principle of both libel and slander is that the communication must be what's called defamatory. You ever hear that old Paul Simon song? Your mama look down and spit on the ground every time your name gets mentioned. That, okay? You have to say something so bad about somebody that their own mother would look down and spit on the ground every time the name gets mentioned, if their own mother believed it was true. I'm exaggerating somewhat, but you get the point, right? It's not enough that what you're saying is false. It's that what you're saying would make ordinary people in the community feel that that was outrageous. And there are plenty of things you could say about somebody that are not defamatory, that would nevertheless be harmful to them. for example, if you were to go down to the poor neighborhood where people are, where people are always looking around and, handing stuff back and forth to each other inside, under their palms or in their backpacks, and you would walk down and say, "Hey, everybody, Google here's a cop." Google might lose money on that. Google's not a cop, to the best of my knowledge, but Google might lose money on that account. Google would definitely lose friends on that account, but Google couldn't sue anybody for that because the courts wouldn't agree that that's a defamatory statement. Okay, defamatory statements are, well, there. I'll give you the idea of slander per se, because remember how I said that for slander you have to prove that you were actually damaged? Well, that isn't true if the thing that was said is one of the following. Number one, that the person has what's called a loathsome disease. Maybe something like leprosy, something contagious, which will follow you for the rest of your life. But we all know what we're really talking about. We're talking about STDs. If you say that somebody has AIDS or something like that, that's a loathsome disease. And second, that the person is unfit for their current job. Make some statement that would suggest that the person is unfit for their current job. I believe the third is that the person committed crime. And the fourth, I am not making this up, unchastity to a woman. Unchastity to, if somebody says that a man sleeps around, the man has to prove that he was actually damaged by that fact. But if somebody says that a woman sleeps around, we just immediately, at least this is the common law answer. There may be reforms away from this. But the common law answer was that if you say that a woman sleeps around, the woman doesn't have to prove that she suffered as a result of that. It's just implied, because you live in a patriarchal society in which the sleeping around of men is, celebrated, and the sleeping around of women is generally punished. See my earlier lectures on the origin of the family and patriarchy and my super feministy stuff about that. Okay. So it must be defamatory. A defamatory communication made to a third person. The next part of it is that it must be false. Originally when they started this, there used to be, way back before the Constitution, back when, the United States was run by the British Empire, there were instances of people being arrested for a crime called seditious libel, which was the idea that you had written something nasty about the government. And somebody had written something nasty about the government and was arrested for it and said in court, "But it's true." And they said, "We looked at the elements of the crime, and we don't care that it's true. You said something nasty about the government. You go away now." I teach in China now. Completely unrelated note. Anyway, the idea of that would change, and it would evolve to the point where it would be said that truth was a defense, meaning that if you said something defamatory, but you could prove that it was true as the defendant, you could get out of it. That has now changed. The rule now is not truth is a defense. The rule now is falsehood is an element, okay? So whereas before it was the defendant's job to prove that it's more likely than not true, now it's the plaintiff's job to prove that it's more likely than not false. And of course, it can be difficult to prove a negative, but that's how you go. Okay, so it must be false. Then there is the idea of publication. I mentioned publication. That's the idea. It has to be said to a third party. And then there is the more interesting concept of fault. And this is very recent. This goes back no later than the 1960s. And I'm going to tell you a story about it in a little bit. once I talk about IED, which will be next. But the basic situation with defamation is this. We look at the plaintiff, the person who has had the shit talked about them. And then we say, what kind of person is the plaintiff? And we divide this person into ordinary people and public people. And I'm oversimplifying a little bit here, but basically there are public people and there are private people. A public person is first and foremost a government official. I'm not talking about the lady who stamps your application at the DMV. I'm talking about the kind of person who runs for office, right? A government official is a kind of public person. And then there's another kind of public person, which is, I'm going to oversimplify it, what I think of as the professionally famous, okay? The people who are famous, not just because one day they happened to save a kitten out of a tree when the journalists were walking by, but the people who are consistently famous, who are constantly in the public light. And I would say the thing that really makes it, and some people might say I'm oversimplifying, I probably am, but I think the thing that really makes a non-government official public person is that this person makes money by being famous. That's how they make their living. Okay? So once we then say, all right, am I dealing with a public person or am I dealing with a private person? I then say, all right, if it's a public person, then the defendant can only be liable for defamation if there is what the court calls actual malice. Actual malice is one of two things. If you heard my homicide lecture, you know that malice already came up when I talked about the definition of murder. I'm now using the term malice to mean something completely different. Malice in this case means, number one, knowledge of falsehood, or B, reckless disregard for truth. Knowledge of falsehood means the defendant knew that it was not true when the defendant said it. It's not enough that it wasn't true. It's that the defendant knew it wasn't true. Or that the defendant had reckless disregard for truth. In other words, the defendant didn't give a damn. If you ever seen a movie from the 90s called Wag the Dog, they bring down, the president's accused of fucking a Girl Scout, I think, and they bring down the master PR guy who arranges to start a war. And, it comes up and they're saying, let's tell a story about a war starting off in Albania or something. And somebody goes, is that true? And he says, what the fuck difference does it make if it's true? That's reckless disregard for truth. It's that what the fuck difference does it make if it's true? So if you have that, either one of those, you have actual malice, and that is required in order to score a judgment when you are a public person as a plaintiff. If you're a private person, most states require negligence. They require basically not only that the defendant was wrong, but that the defendant should have known they were wrong. They should have looked into the matter more thoroughly in order to figure that out. Okay? And why do we make this distinction between public people and private people? Well, the law thinks that, if you're just going along like anybody, it might be all right to give you some ability to stop people from talking shit about you. But if you work for the government or if you are famous for a living and you don't like the fact that people talk shit about you, then the solution is to stop working for the government and go get a real job. And then you can have the right to sue people who talk shit about you. Okay? So, and the reason why we have this is the United States law, because it comes from the United States Supreme Court, because people had said, when I insult a politician, when I insult a professionally famous person, my first First Amendment rights should be protected. And that is the compromise that the court found in that matter. Okay, so that's the basic idea of defamation. And then there are some others. There are other ways that you can get sued for the shit that comes out of your mouth. And the next one that I want to talk about is something called IIED, intentional infliction of emotional distress, also called outrage. I just like to call it outrage, but, everybody calls it IIED because everything has to be more complicated than it needs to be. Whatever. Intentional. If you'll remember my talk about murder, intent means purpose or knowledge. Same thing here. That you wanted the thing to happen, you wanted the emotional damage to happen, or you knew the emotional damage would happen. Infliction of emotional distress. The emotional distress must be what's called severe in order to be compensable. What's severe? Basically, it either has physical manifestations or it costs you money to fix it, right? We're not talking about, I had a bad day and I had to go have a drink after. We're talking about sleepless nights, therapy sessions, had to get on the SSRIs, whatever, that stuff. Yes, Google?
Would this include like significant losses amount of money as well? Like a
I don't
loss in
understand what you mean.
income? Like
In other words, is that a compensable damage if you can prove a case of
yeah,
IAD? I think that
yeah.
probably, yeah. Because generally
Okay.
special damages are allowed in torts cases, and it's a tort. So that's a consequential damage. Consequential damages are special damages. Special damages are allowed in torts cases. So my vibe would be if you had to miss work because you had to be, put in a mental hospital or something, then I guess, yeah, I would guess the hospital bills and the loss of income would probably be compensable, is my sense of
Okay.
that.
Thank you.
Yeah. So, um, but what sort of thing are we talking? Well, it involves an outrageous act that intentionally inflicts severe emotional damage. What's an outrageous act? Well, the thing that will get it done for you every time is mishandling of a corpse or mishandling of information about a person's death. Going up to a 12-year-old and saying your mommy died in a car crash and she was decapitated, and just at the moment, those last 7 seconds before she expired, her talking head said, "Tell Timmy I don't really love him." Saying that to 12-year-old Timmy is an outrageous act, okay? And it takes serious shit. Now, if the defendant knew that the plaintiff was particularly sensitive to certain conduct, then that may be taken into account when determining whether or not it was outrageous. And the case goes like this. There was a guy, I think he was a factory worker, and he had a mental health condition called BDD, body dysmorphic disorder. See, when I look in the mirror, I go, my hair's kind of messy, could stand to lose a few pounds. Fuck it. But when somebody with BDD looks in the mirror, they fixate on whatever they perceive to be the problem with them. So this guy in particular, it was his nose. He said, "Oh, my nose is so ugly. It's ugly. No one will ever love me." And it just fixated on it. Can't take the eyes off it. And this guy had BDD. And everybody at his job knew he had BDD, including his boss. And his boss knew that his fixation was on his nose. And his boss would torment him day after day after day. And this ended up to the court saying, yes, that's outrageous. I mean, if if you say to somebody who doesn't have BDD, hey, you have a big nose, then, that's not outrageous. But, in a case like that, it would be. Actually, in that case, I think the guy ended up losing for a different reason. But that's the outrageous aspect of that. Okay, so that then brings me, let's see how we're doing on time. Oh, look at that. Yeah, this is going to be a short class. Okay, so that then brings me to the constitutional aspects of IIED. And this is the time that I get to tell you to go watch a movie. I think they might have it in Movie and Chill. I haven't looked, but they probably do. Find it someplace. It's called The People versus Larry Flynt. LARRYFLYNT. This is the real history of a case called Hustler v. Falwell. Back in the 1980s, before Twitter, people used to engage in Twitter wars in magazines and on TV. That's where they would proceed to have the celebrities talk shit about each other. And back at this time, there was what we would call a Twitter war between a couple of celebrities. On the one hand, a man named Larry Flynt. Larry Flynt was the owner of a magazine called Hustler. Hustler made pornography. Not just pornography, but for its time, really, really dirty pornography. I mean, this was at a time when the pornography, he according to the movie, saw himself as kind of in opposition to the tasteful pornographers. Read Playboy, where the centerfolds put the leg up and the cheesecake is the word. Hustler was on the idea that he didn't want to be in that business. He wanted the full frontal and the penetration and all the dirtiest, nastiest shit you could print. That's what he wanted to print. And built a successful empire on this and went to jail several times for it, but I'm getting ahead of myself. On the other side, a man named Jerry Falwell. Jerry Falwell was a preacher. Not like a regular preacher, like a megachurch preacher, like a Joel Osteen type person. The kind of guy who tells you that Jesus loves you very much, but he would sure love you more if you gave me $1,000 today.
Oh.
That sort of guy. And Falwell was connected politically, up the right wing, up the Republican Party. And back then, one of the things the Republicans were up in arms about was pornography. And so, of course, Falwell would use his TV show to tell all the little old ladies that if they just gave him more money, that God would somehow ban pornography. I shouldn't knock him. He actually was a very skilled political operator, and the recent Dobbs case outlawing abortion has his name on it in many ways. But was mobilizing people against pornography. So Larry Flynt has written up in his magazine a piece of satire where they would have, he printed regularly things said whiskey. It was a certain brand of whiskey. I forget the name of it. And it said, so-and-so talks about his first time. And these would be full of, and would be, the story of this celebrity, that celebrity, having their first time drinking this particular brand of whiskey. But it would all be written in such a way as you wouldn't be able to tell whether he was talking about his first time drinking whiskey or his first time having sex. And so Flynt causes a fake interview of Falwell. Jerry Falwell talks about his first time. And it goes on, it's like a full page with a long, detailed story of Jerry Falwell's first time. And it says that Jerry Falwell's first time was with his own mother in an outdoor toilet, like an outhouse.
Oh my gosh.
Okay? Yeah, I mean, you couldn't, I mean, you know, this is way beyond step bro, I'm stuck in the washing machine. Way beyond that. And so this I don't know anything about that. Anyway, this gets published, and Falwell sues Flint. And he sues him for, actually, Flint countersues for copyright infringement, I think. Just as a little fuck you back. But, pardon me. That seems to be disappearing. Okay, but anyway. The case goes to the jury, and the jury says he didn't defame you. There's no defamation here. Why not? Well, because to make a defamation case work, and I should have mentioned this earlier, to make a defamation case work, it's not enough that it be outrageous. It's not enough that it be false. It's not enough that it be a public person. It's not enough that you know that it was false. Furthermore, it has to be a matter of fact. You can't just give an opinion. And it does not apply to situations where the story is so outrageously, bizarrely stupid that everybody knows it's a joke. The story has to be intended to be taken seriously to amount to defamation. And because everybody understood that this story was never intended to be taken seriously, they said there's no defamation. But, said the jury, we do have a case of IIED. Now, I am not aware that Falwell actually suffered severe emotional distress. The jury seems to have forgotten that, as far as I know. I'm not aware of any evidence that Falwell actually had lost sleep, that he had to go to a counselor. I don't think that ever happened. But the jury was just so outraged at Flint that they wanted to throw something at him. And if they had thrown defamation at him, it would have kind of been like to say, okay, yeah, we kind of believed it for a second, right? So they found him not liable on the defamation, but found him liable for the IIED.
Hello.
And the case goes to the United States Supreme Court, and the United States Supreme Court agrees that IIED has a public person exception. That if you are a public person, pretty much you don't get IIED protection for public statements made against you. Because if Falwell didn't have it, pretty much nobody has it. Like, yeah, there might be a sliver of a theoretical possibility, but if Falwell didn't get it, pretty much no public person is going to get it. Okay? So that is defamation and IIED. There's a little more other ways that the shit that comes out of your mouth could get you sued. There's the concept of false light, where you might make a statement about somebody which is false in such a way as to cost them money, even though it's not outrageous. Like, say, Albert is in the business of selling paper clips or something, and Juicy is Albert's competitor, and just before Albert has a big meeting with Google, who's going to buy tons and tons of paperclip, Albert gets stuck in traffic, and Juicy says, "Oh, Google, I heard the worst news. Albert died. Sorry." And Albert says, "Oh shit. Well," and he's, we wouldn't get the IAD because they're not related to one another, just for the mishandling of the information. But Juicy steals the deal out from under Albert with that information.
Dang.
That would be an example of false light. And then there is the concept of public disclosure of private true facts. This is part of a family of torts called the invasion of privacy torts, and I don't want to go into the other three, because those are not things that you get in trouble for the shit that comes out of your mouth, and this is what I'm talking about, the shit that comes out of your mouth. And, excuse me, anyway, the public disclosure of private true facts would be something where, yes, it's true, but an ordinary person would, the plaintiff, in fact, intended for this piece of information to be kept private, and an ordinary person in the plaintiff's position would have expected that that information would have remained private. So let us say, I have no reason to believe it's true, that Albert has cancer, and that Albert wishes to keep this information from his loving sister so that his sister won't worry about him. Well, in comes Google and, happens to come upon, this information somehow, and then proceeds to take out an ad in the newspaper telling everybody about Albert's health condition. That's public disclosure of private true facts, and Google in that instance could be sued for it. Okay, so then let's see if I can think of anything else. There are newsworthy exceptions. If something is newsworthy, and if it has ever been newsworthy. It used to be that something is newsworthy only for the news cycle. But if it's ever been newsworthy, it's always newsworthy. So if it's, worthy of printing in a newspaper, provided that the journalist exercises reasonable care to make sure that the thing they're posting is true, then, then you have that protection. And then there are some other things, like things you say on the floor of a courtroom can be subject to a certain amount of protection. And one of the nice things nice things about being in Congress is that there's an absolute privilege against defamation for anything anybody says on the floor of Congress. And, also, political ads, as I've already talked about, since they are always against a public person, we see political ads which are just full of all kinds of falsehoods and shit, which are basically very difficult to disprove, and most people don't even bother to sue about those things. So that is the time that you can, the things that come to mind, of the times that you can be sued for the sort of shit that comes out of your mouth. And that's, let's see, we started, it's about a 30-minute class. It's a pretty short one today. That's okay. Any questions?
I have one.
Yeah, sure.
So would like most I was going back to the satire of Mr. What's his name posted. So if you say that this is a parody or a satire before you start, talking shit about anyone in a funny way, would you be protected against defamation?
Well, I mean, yeah, as long as everybody knows that it's not intended to be taken seriously, then you would likely be covered under defamation, but remember, you might still catch an IIED. Right? Because even if Falwell had said, and I think he actually did, even if Flint had said, and I think he actually did, this isn't real. Just the idea of painting an image in the public mind of a preacher's first time having sex to be with his own mother in an outhouse, I mean, that disclaimer will only take you so far. It may save you from the defamation, but it won't save you from the IIED. For that, you need the United States Supreme Court to decide that you can more or less talk whatever shit you like about a public person, which they did. But if Falwell had not been a public person, if it had just been, Nathan was accused of this, then, it would be a different outcome, most likely. Or maybe Nathan's a public person, but, I might be big on TikTok or something. I don't know. But yeah, under those circumstances, I would say if Falwell hadn't been famous, then giving the disclaimer would save you from defamation, but it wouldn't necessarily save you from the IAD. But it would have to be it would have to be beyond defamatory. It would have to be amazingly, amazingly bad.
Wait, can you explain again, the scaling of how, if you mentioned someone would be famous, they, oh my god, I'm too stupid. What do you say? Were they protected from the defamation, right?
What I said was right. So if the plaintiff is a public person, then in addition to all the other elements, to make a defamation case, you have to prove that the defendant either knew what they said was false or that they didn't give a damn whether what they said was false. Whereas if the plaintiff is not a public person, you have to prove only that the defendant should have known better.
I see. What is the scaling of, say, that famous person? Like, if there was like a movie actor, that would be famous. What about someone else that's like at least well known but not famous in the sense?
There is a gray category. I think there is such a thing as a partially public person, which may be less protected. In that case, generally, I think what we do is we say that they are a public person within the capacity in which they are public. So, like, if you are a famous winemaker or something, then you're a public person insofar as I talk shit about your winemaking skills. But if you have no other part of your life as a public person, then, if I then talk shit about, fucking your mother in an outhouse, then I think generally we would then treat you as a private person. I think that's the way that breaks down. Don't hold me too closely to that. But that's the major thing to keep in mind is the public person versus the private person, and a public person is a government official, or Professor Pure's definition, basically somebody who makes a living by being famous. Because if you don't want that sort of thing said about you, get a real job.
Yeah, because it just seems to me like when you think about it, there could be someone who is in the middle, and yet if someone does get like super defamation, and that person is in that middle position, it's kind of hard to determine what they're placed in.
And like so many things, when we have a question and we don't know how do we figure out who is a public person and who is a private person, what we do is we get 6 or 12 randos together, we tell them that we will not question their decision, and then we just ask them, what do you think? It's a jury question. As an old law professor of mine used to say, this is a question for a jury of your peers. And you know what that means? Third graders! By the way, I should say that it really does depend. If you're in a rich county, I mean, it's not. I've been in juries where there was more than one PhD in the place. I've also been in places where they were third graders. Yeah.
I'm sorry. What?
It's a rich county, poor county thing.
Can you bring kids as a jury though?
Can you what?
Bring kids.
No,
as
the
a
knowledge
jury?
would be compared to third graders.
Oh.
Yeah, well, no, not just that. I mean, we don't require in the United States that jurors know how to read and write. There is no requirement that a juror have formal education in the United States. This is different from China. When I tell my students that there's no requirement of any education on the part, they really? Because in China they have to have and not only in China but also I believe in Japan and in many countries. You serve on a jury. I mean, it's like a part-time job. You don't just take one case. You take case after case after case for a number of years, and you have to have some level of education, maybe a little past college, to get in. But the United States tradition is that we think that the jurors should be made up of the a cross section of the community is the legal term, but we like the idea that the jury is made of the common people. And the reason for this is that when you have power, I mean, one of the major reasons why power corrupts is that when you have it, everybody lies to you. And I will prove this to my students by walking up to one of them and saying, "Did you do the homework for last night?" And they will every single time look back at me and go, "Yes." And then I'll say, "There was no homework last night. I made it up." And see, when you have power and you demand things of people, people lie to you. It doesn't matter whether you're generally a nice person. And what that means is that when you are a judge, everybody lies to you to the point that you can't tell the truth from the lies anymore. Power has this effect on people. It makes it so you can't tell the truth from the lies. So what we do is we just take some of the least powerful people we can find, and we say, yeah, let them decide.
Also, I have another question referring on like defamation and whatnot. Let's just say, for example, on a scale where a movie maker makes a movie, right? And it gets published. And there's a whole bunch of movie critics that, obviously they write down their comments, blah, 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 and all that too. Then there's that one comment. Let's just say it comes from a low class. I'm not saying low class, but from a lowly, like, not recognizable. But yeah, he is actually a good movie critic.
Yeah, a little known, obscure movie critic.
Yeah, he says. On a specific note, like targeting to the movie maker, his movie making skill sucks. I don't like how he makes his movies from what I see. Is that considered defamation or not?
Of course not. Because it's an opinion.
Even though he didn't say "I think," or he literally straight up says like this guy's movie making
sucks.
So
first of all, saying "I think" doesn't make it not defamation. Nor does saying "I heard." Nor does saying "I heard from so-and-so." But the reason why that isn't defamation is that to say that somebody sucks is not a matter of fact. It has to be something which could be believed as a matter of fact, right? We're not to say that Falwell fucked his mother in the outhouse. That is a matter of fact. Either he did or he didn't. To say that Falwell is an idiot, however, is a matter of opinion. See the difference?
Yeah, so if you say like he killed like 3 people during the production of a movie, that would be defamation.
Right. I mean, yeah, I think in most cases, probably, yeah.
So, for example, what would the state of gossip be?
The state of what?
Gossip.
Gossip. Well, I mean, you just run the test. I mean, is it a matter of fact? If it is, I mean, because repeating what somebody else, just saying I was repeating what somebody else said will not save you from a defamation suit. Whoever you heard it from may also be in deep shit, but you would be in trouble if you repeated it. Yeah. Theoretically, if you're talking about a private person, you can make all the other elements of defamation, generally speaking, yeah.
Okay, but even so, the origin of a person gossiping is what we consider as defamation, right? Because it's inflicting towards one person.
We're not necessarily going to ask about the origin of the gossip.
No, not the
right?
origin.
Because you'll never find the origin of most gossip.
No, I'm just saying.
Whoever is repeating it, if that's who ends up getting sued, then that's who ends up having to pay if they did it.
No, I'm just saying at the matter of hand, though, like whoever stated it is, that's defamation itself, anyways, right? And it gets passed on. Gossip. Whoever stated the gossip at the start. Then when it gets passed on, then it gets even more and more and more. That even so, like the person who started it, though, doesn't matter. Like it doesn't matter who if it kept on going or not. The person who started it is still
right. Well, remember, let's assume we're dealing with a private person. Understand that still in most states, the defendant has to have been negligent.
Negligent. Okay.
But if you're just repeating the gossip that flies around in the air, yeah, that's probably negligent. I mean, if you heard it from if you heard that somebody had cancer from somebody who said that they were their doctor, then maybe you weren't negligent. I've heard that, not cancer, but a loathsome disease. You heard that somebody had AIDS from somebody who said that they were their doctor and they were wearing a white coat and they seemed to be a doctor, then maybe you would be able in that case to say, well, yeah, I repeated it, but I wasn't negligent. But yeah, that aside. But if it's just the shit that is flying around and everybody knows you can't necessarily believe these things, you have a general obligation to be aware of to take reasonable steps to make sure that what you say is true. Then yeah, you can do that. You can.
Then what's
that's how that works.
Then what's the loophole? I heard there's a loophole for this one too, especially when someone says like, I heard from not from, but I guess that could also be within that case. But there's also like saying like, I heard from this person, or I heard that this blah 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 blah.
Nope, that will not save you.
Still, okay, because
that will not saying I heard that or saying I think that from. If a defendant says I heard that or I think that, and then they proceed to say something that is defamatory, the I heard that or I think that will not protect them.
Okay, no.
Doesn't it depend upon the source you get this information from? Like as you said, if it was from a reliable source, like a doctor,
if you
right?
say I heard from, if you say I heard from a source and that source is reputable, then that, and you did in fact hear from that source. You don't just say you did.
Mm-hmm.
Journalism.
Then
but at that same
that may
time,
be an indication that you are not negligent.
Say it was a doctor you heard it from, right? Wouldn't that be a violation of their privacy laws they have in place?
Right. So you might then find yourself facing a public disclosure of private true facts case. In that case, yeah, certainly possible.
That's kind of what I was thinking about. I just didn't want to interrupt.
But public disclosure of private true facts is different in its publication element than is defamation, right? Defamation requires that you say the thing to a third person. Public disclosure of private true facts, when that says publicize, it means you say it to the general public. So you might therefore have somebody who says, let's say that Albert has cancer. Again, I don't think he does. And somebody hears from Mari, Albert's doctor, that has cancer because Mari accidentally left the report out on her table or something when the next patient came in, whatever. And then that patient goes and tells, Albert's little child, Nathan. There's no publication there. For purposes of the public disclosure of private true facts. There's publication for purposes of defamation, but not for public disclosure of private true facts.
Hold up.
Is it IAD? Well, maybe not. Remember, it requires intent. So maybe you told the person, and it might also not be seen as outrageous, because the same thing that is defamatory is not necessarily outrageous.
Wait,
right?
question.
To say that somebody is
for it to be outrageous,
to say that somebody is to say that somebody has a loathsome disease, or let's say, for example, remember I told you that to say that a woman is sexually unchaste is slander per se, meaning it's defamatory per se. Well, okay, fine, but it's unlikely that saying that is outrageous. Just say, oh, she a hoe. Like, yeah, okay, maybe that's defamatory, but it's unlikely that a court would hear that and go, oh, wow, she lost sleep over it and had to go years of therapy because, her son's kid called her mama hoe, right? I mean, it's outrageous is a way higher bar than defamatory.
There's something else I was thinking about too, especially when there's a thing with speculation and all that too.
Yeah.
So what if one can?
I said.
Oh, sorry.
Yeah, I mean, I said if you say I think, that doesn't save you.
Even though someone could object, that person could object for it within speculation or such.
Right. Well, don't think in terms of objections. I'm not talking about objections.
I'm talking about objections. I'm saying someone could actually, could assume within that point it could be speculatory or whatnot.
So what?
So someone says, I like, oh,
yeah, that doesn't make a difference. So understand this. In physical reality and in VR, we have time plus 3 dimensions. Okay. Up, down, left, right, forward, back. And in order to know where we are in physical reality or where we're going to meet, we need a piece of information that will tell us something about all 4 dimensions. Otherwise, I'll never be able to meet you at the right time at the right place. Okay? So there are the 3 spatial dimensions of physical reality. In law, we also have three dimensions. 3 things you have to know something about in order to know what is going on in your case. The names of these 3 dimensions are substance, procedure, and evidence. Substance. What is the law? Like, what does the law say should happen? Procedure. What is the process by which the law takes the things that shouldn't happen and turns them into the things that should? And evidence. How does the law figure out what the hell is going on anyway? Okay? If you want to understand where you are in any case, you need to understand all 3. You are asking me questions, talking about objections and speculation. You're asking about evidence. And today's lecture is about substance.
Okay.
Okay?
Got it.
Okay. Now then, anything else?
I think that should be it for my case. 3-parter.
Okay.
Nice.
So I wish, and I should say that I have told Kipsy that we're doing this, and Kip has had something come up, and he says that we can discuss this in his absence. And without wishing to provide guidance, Juicy says that he'll, give if whatever it is to Kip. But I don't know much about this case that Juicy and Kip are running. All I know about it is that somebody's getting sued for the tort of being bald. And it just seems to me that this probably sucks. Nothing personal. It's just that, there's a reason why 95% of cases settle. It's that 95% of cases are boring. It's really hard to write good legal fiction. You can't just take any dispute and then throw it in front of a courtroom and all of a sudden it's entertaining. Right? I know this because I think I'm usually doing pretty well if I write 1 story problem a day. That's me being creative.
Well, that's only part of the case.
Okay, so I wanted to brainstorm this with you, and maybe somebody can give me the rundown of it. Would you mind,
love to be
please?
present too.
I mean, I don't mind. I don't know if it's proper for Juicy to be here.
Okay.
Or Juicy can give it to you.
I mean...
Juicy, go ahead.
No,
I can give you the basis of what it's supposed to be.
Okay. Why don't we start with that?
So the basis of it is that Slap, the plaintiff, had came to me because he wanted to he wanted to get the OnlyCans people to stop saying that he's bald when he really isn't. So he wanted to bring them to court to get them to stop doing it. The other part, the second half, is along the same lines, but it is that to prove that he doesn't have a Grindr account.
Okay.
Do you know
so
what a Grindr account is, Pierre?
By reputation.
Yeah. Good answer.
So
Gay Tinder.
I know of a lot of things by reputation. Okay. Right.
So technically, it is a 2-part case.
Okay.
They probably just haven't gone over with their clients the second part of it yet.
Right. Okay. Well, let's see what I can do to make that a little truer to the situation because okay, well, I guess you can. Okay, I'm worried because I'm like this. I worry about ethics all the time. I worry that somewhere out there on the internet that maybe this person actually has BDD or something like this, and oh my God, I don't want for anything like people to actually
I have to tell you now, this case is supposed to be fun. That's why it's so silly.
Okay, yeah. So then okay, so let's see. It's interesting then, because if he wants them to stop, okay, this is not a bad case then. So I'll give my thoughts on it.
Because overall, it's the whole Slap gets teased constantly by everybody, and he kind of wants it to stop. But whether it stops or not, well, I think now it's more of who does
you're gonna have a Streisand
upper
effect.
hand.
AKA first grade drama.
Who has the upper hand? Can they prove? Is the possibility of getting them to stop gonna happen? Is basically the
right.
process.
So I guess there's a couple. The first thing is
after all a fun event for everybody to go to.
Right. So I'm asking myself on the one hand, whenever I assign people to write stories for my students to argue about, I have a form, and I say, what would it take to get the plaintiff to win, and what would it take to get the defendant to win?
Mm-hmm.
And it sounds to me, if he's not bald, then it's hard to. But then, okay, fine, it might not be defamatory, because being bald is not actually defamatory. So I guess you could have some argument about that, but I guess the important thing is that this person is, for everybody's entertainment, going to cry out, "Why don't you stop making fun of me?" And I don't know, it doesn't fit my sense of humor, but I guess people go for it.
As outrageous.
I had imaginings that it was we would imagine some alternate universe in which everybody lives in absolute fear of Agent 47, and so the government prohibits the shaving of heads. Something like that, because they might leave DNA on crime scenes or something. I don't know. But yeah, okay. I don't know. I don't know what there is for the lawyers in that case to really do, except I guess somebody could get. The question might come down to remedy, right? What exactly could you get an injunction? Could you get the court to? I don't think you could. I don't think you could get the court to say, "We will. I'll send you to jail if you call him bald again." I don't think you could do that. I think you might. You couldn't get anything for it. As for the secondary issue, the proving that he has no Grindr account, that sounds like, I don't know, what is there for a judge to do, is my question about that. Right? They just sit there and be like, "We are now noting that you don't have a Grindr account," or we are commissioning a special investigation to comb all through Grindr and look at every profile we can find in order to prove that it doesn't exist. That could be entertaining in its own way.
Who knows? We may find the sexiest man alive.
Just scrolling Grindr.
Who knows?
Yeah, you just have the entire court just scroll through Grindr pictures and go, "Is this you? Is this you? Is this you? No, that's not me. That one, that guy's only got a 9-inch cock. I've got an 11, or whatever."
Instead of 3 million photos, you know what I realized? Instead of 3 million photos would come, it's 3 million men with freaking.
I'm pretty sure that the only thing they're really suing for is how many drinks do they want to give the other person. They're drinkers.
Splendid.
Yeah, the OnlyFans guys are just party people.
Yeah, they're just party people. So if anything, whoever wins is probably getting 120 drinks. It's a lot, but
I would assume that we're actually trying to prove that
it's kind of one of those things where we're having fun with it, and it doesn't really need to be that serious. However, getting a basics.
I'm overjoyed to hear that. I tend to overthink things, as you can probably tell. So, I believe that concludes everything that I had wanted to do at this particular law class. Yeah. So,
I guess I've been working
class
on my
dismissed.
Yep.
Alright, cool. Great.
Class
Awesome.
dismissed.